Hi there, welcome to Law Call. I'm Neil Gordon. Tonight, the answers to your legal questions. Here's what's ahead on our program. First, in our caller segment, we'll discuss all types of personal injury claims. So if you've been hurt and you just don't know what to do, we invite you to call us at 803-442-4551. And later on in the program, we will also talk about divorce and who gets what. First, though, Attorney Vic Hawk is here to take a look at one of your email questions. And on this Grammy Award-winning rainy night, we are very excited to be here. Good program.
Absolutely. It's going to be a great program tonight.
This email question, something I always enjoy, deal with business and contracts. You have to be careful. Max wants to know, Vic, why do most agreements or contracts you see have some sort of arbitration agreement in them? And Vic, are arbitration agreements binding?
Max, the reason that they have the arbitration agreements are twofold. One, to cut down the expense of litigation, and two, in a lot of cases, to gain an unfair advantage. And the unfair advantage arises from requiring the arbitration to occur in Minnesota when we live in Georgia or Oregon. Arbitration law is very complex. In fact, when I saw the question, I spent some time looking into how the courts have dealt with it. It is a very controversial issue right now, depending on the nature of the contract, whether the federal government has preempted state law, and whether state law applies solely to the particular contract, will affect whether or not they're enforceable. And the easiest way for you to look at it is our Constitution is the supreme law of the land. Then our United States Congress passes laws, and no state can pass any law that violates federal law or the United States Constitution. And so if the federal government has issued a law or made a law which affects the particular arbitration agreement that you're involved with, then federal law will generally govern whether or not it's enforceable. If it is not, then state law would apply. But every contract, every case is different, and you'll have to look at the individual circumstances of the contract.
And on a broader basis, never do a contract yourself. Have an attorney involved.
Yeah, you really need to do that. Although, in all fairness, as a practical matter of daily living, when you get a checking account, you're going to be signing a contract. When you get an insurance card, you're signing a contract. When you buy something, you're signing a contract. And there are all kinds of clauses in there that can affect your rights and duties. So it's always best to take a look at it. But before you make a decision as to what you should do in the event of a conflict, you should contact an attorney, and just don't take the word of the other side as to whether or not that contract's enforceable.
The big print giveth, the fine print taketh away.
Oh, we see that every day.
Yeah, I've been told that. Great question, Max. If you'd like to get involved with an email question, we invite you to go to a few websites. One is VicHawkLaw.com. You can also go here to WRDW.com. There's a great Law Call page with a bio of Vic and more information on Law Call. And on the right there, the red bar for you to click on. And again, fire away those questions. We'd love to hear from you, and we'll chat about it on an upcoming program. We would like to take your questions live. Again, the phone number, 803-442-4551. Vic, a big part of your practice has to do when people get hurt, they call you, and so you naturally brought on someone you work with on a regular basis.
That's right. I brought on Reed Sanders to work with us tonight. Reed is an excellent young trial attorney. He does a lot of the premises liability litigation in our office, and has developed a little expertise in that area, and is getting ready for some trials that we're going to try in the next few months. Reed, can you explain to our viewers why a landowner or a business owner could be held responsible for the criminal act of another?
Sure. Well, the first thing is a landowner or a business owner, they have a duty to keep the premises safe. And most people think, and rightfully so, that means premise safe from hazards like a pothole or a faulty step. But they also have a duty to keep the premises safe from somebody attempting a criminal act against you. And to get the business owner to be held liable or be responsible for it, you also have to show notice. And basically what that means is there has to be other events similar events that happened prior to the one against you that could make the business owner on notice that that could happen to you if they didn't do something about it. Now, this could happen at a bar. This could happen at a restaurant. We have a case in our office right now that it happened at a motel. And one of the situations was that the motel told the guests that they were going to provide security, and they did not. They also told the guests that they had a 24-hour system that you could call and somebody would answer the phone and take care of you if you had a problem. Well, somebody came to the door and injured, our person, and they tried to call down there and nobody was there. Nobody answered the phone. So that's a situation where the business owner or landowner didn't do what they told the guest that they would do, and therefore the guest was injured.
That's a big area of litigation right now. You see it in a lot of cases where we have another case in the office where a particular restaurant had over 235 prior calls to the police with regard to criminal activity in the immediate area or within the restaurant, and they still failed to provide security, and someone was shot, a customer was shot there on the premises. And under circumstances like that, the landowner, the premises owner, the owner of that business can be held responsible for the injuries to that customer. A classic example as to how important that is would be Regency Mall. Once those two ladies were kidnapped and assaulted on the premises, that mall was dead. And that's why Augusta Mall provides security inside and out all the time to protect its customers.
And we'll make one more point on that. A lot of people will say, well, shouldn't the criminal be held responsible? And they are. They're prosecuted. But the problem with that is most of the time the person who committed the act isn't going to be able to afford to pay for somebody's health care and for that person to get better. So having somebody like the business owner who would have insurance and other ways to pay for that health care, the laws have set up to kind of have a safeguard for people who are injured that way.
We have our first call of the evening, or the morning rather. Josh joins us from Augusta. Josh, are you there?
Yes.
Okay, thanks so much for calling in. Josh, we understand your question's related to jail. Were you or a family member in jail?
No, I was there, and I gave them my medicine, and they didn't give it back to me.
Yes.
And, I ended up on disability. Coming out of jail, I ended up in the hospital,
Josh, that's a common thing to occur in a jail, and really your lawyer, whether the lawyer was appointed or you retained a lawyer, should have called the jail, especially the jail nurse or the jail doctor, and ensured that you got your medicine. They're required under your basic constitutional rights to provide you reasonable medical care that you need in order to cure any disease that you have or help you to get over any particular medical problem that you have. So you would have a remedy against the Sheriff's Department if they fail to provide you medical care that you should have received and it caused your disability.
And to recover on something like that, you're going to have to show that not only you didn't receive the medicine, but that by not receiving the medicine, it caused the injury. Because obviously if you're taking medicine, you already have something going on.
Yeah.
Well, our topic is all about injuries, and we'd like to invite you to give us a call. The hour may be growing long, but we're here and we really like to help you. The phone number 803-442-4551. We'll be right back with more of your questions here on News 12 Law Call.
Divorces, Georgia is an equitable distribution state. This means that the division of property and debts between the divorcing parties should be fair and equitable, but not necessarily equal. There is no fixed standard to divide property, so each case will be decided on the facts. Generally, property division for a short-term marriage is pretty straightforward. When few or no joint assets have been accumulated, the tendency is to unwind the marriage. This means giving back to the husband and wife what each of them brought to the marriage and then dividing up the assets and debts the parties have accumulated since then. The longer the marriage, however, the more difficult this unwinding may be. For a long-term marriage, judges will typically begin with something like a 50-50 division of the estate. A judge has the freedom to depart from that 50-50 standard, and sometimes fairly dramatically, depending on the circumstances of the divorce. I'm attorney Melissa Detchmindy of the Vic Hawk Law Firm. Back to you.
Well, that's great information for public service, because you all don't cover divorce, don't do divorce, but you like to share that information.
That's right. And we know good divorce attorneys, and we can help you out if you need a referral to a divorce attorney. We just don't do it.
Understandable. Got to have area of specialization. There's
right.
All About Injuries, and that's where we turn to Cassandra, who has been waiting patiently through the break from Augusta. Cassandra, how are you?
I'm good. How are you all?
Good. Briefly share with us what happened to you when you were in the hospital. I guess you got an infection?
Yes, I was admitted into the hospital, went to the emergency room, and was diagnosed with pancreatitis. And after being in there for like a couple of days, the pancreatitis was split up, and I noticed through the IV in my arm it had a foul smell. And I called it to my nurse's attention, and they continued to administer a medication through this IV, and I got a fever. And once I got the fever, they became concerned, and they started running tests on me, and I had developed staph infection, which prolonged my stay in the hospital for like additional 7 or 8 days. And I had to have a PICC line put into my arm. And for 21 days, I had to go and have antibiotic infusions every day,
Right.
even on Saturdays and Sundays. And I lost wages. And after the antibiotic infusions, I had to take oral antibiotics for 21 days.
Well, I don't think that, I think you're discussing the damages, and I think you have plenty of damages. I think what the problem is going to be is trying to attach that liability. In a situation like this, it's probably going to be a medical malpractice claim, and when you have a medical malpractice claim, to be successful, you're going to have to show that they did something that they should not have done. Anytime that you go to the hospital with an injury or a problem, you run the risk of the treatment not working or not being successful. And if you have any kind of surgeries or anything like that, you may actually wind up worse than you started. And that's kind of a risk that you run when you, like I said before, when you can be successful in that scenario is if they should have done A, B, and C, and they did A, D, and Z, then you may be able to show that they didn't follow the right steps and procedures, and you can attach some liability. But if they did the steps that they were supposed to and something just didn't go right, unfortunately, you're probably not going to be successful attaching liability.
Yeah. Staph infection cases are extremely difficult to pursue because really the hospitals cannot prevent them.
Yeah.
The germs just mutate very quickly, and it's very difficult for the science to keep up with the infections. And that's why they try to get you out of the hospital as fast as they can.
Well, we have a call on the other side of the river now. Susan joins us from South Carolina in an accident some 8 years ago. Susan, what was supposed to happen, I guess back then in 2005?
Yes, I almost hit them behind on Finch Avenue and not completely around. Almost at Finch All Social Service, not completely around in the parking lot. Well, the judge told them, says, you got to pay her car payment because my car was totaled off. And said, if she has any future surgeries and anything from it, you have to pay it.
Susan,
now,
hold on just a second. I think the question is the statute of limitations already expired?
Well, maybe not. Did you pursue a civil claim, Susan?
I ain't done anything yet. All I did, the judge told me that he would have to pay in the future.
Right.
That any medical thing I had, if I didn't have surgery or anything in the future,
Susan,
that he would have to pay for it.
Did you have a lawyer represent you in the claim?
Sir.
All right. And so what happened is you appeared in traffic court with this person who was charged with being at fault. Is that right?
Uh-huh.
And then the judge ordered that restitution be paid. Is that right?
Uh-huh. And all my
I-
victim medical bills.
Yeah. I think the only thing you can do is go back to that judge, go back to that traffic court, and ask them to enforce his order of restitution. And my concern is that his probation has already run out, and therefore the judge may or may not have the ability at this late date to order these payments that you're asking for. But as far as a civil claim, your statute of limitations is run. It's gone.
Well, thank you for calling in, Susan. If you'd like to get involved, the number 803-442-4551. The last break and more of News 12 Law Call. And we're back with Vic and Reed, and want to give you the phone number one more time, 803-442-4551. We have a couple of callers. Want to get to them before we scoot. Phyllis from Georgia joins us, who was hurt at the store. Phyllis, what ensued with your attorney?
My attorney was in Atlanta. He came to see me, and we discussed the terms and everything, and what and the case. And then he said they would take the case.
Right.
And then a year later, they decided they don't want to take it anymore.
Okay. Well, probably what happened is they ran into some liability issues and didn't want to do any work, and to be honest about it. But they are allowed to get out of a case unless you have like a criminal case where you paid a retainer agreement. If you had paid them, then they have to get a judge to release them from the case. But if it's on a contingency basis, then they probably would be able to get out of it. But to be honest with you, you're probably in a better situation, because if you have an attorney who's going to get out of a case just because it becomes difficult, it's not a very good attorney to have. So now you can go find yourself a trial attorney that can help you. But in most situations, you're going to have a statute problem. If it's already been a year, I'd do that immediately.
You know, I see this all the time. It comes into our office day in and day out. If you go to a lawyer that's not willing to go to court for you, you're going to run into that situation. And there are advertising attorneys on TV every day. And I have told y'all from the get-go, if you go in to see an attorney, you should get a trial attorney to help you out, because you're going to miss 6 additional opportunities to settle your case. Ask that attorney, have you tried a jury trial in the last 2 years? Have you ever tried a jury trial? There are some of them on there that you can ask them, have you ever tried a jury trial? And they will say no. And that's who you're turning over your life to. So think about it, and then you won't get into that particular situation. Generally, a good trial lawyer is going to investigate the case as quickly as possible, and they're going to use those facts to make an early determination as to whether to pursue your case. I'm sorry that happened to you, but you should either consult a trial lawyer immediately to get the help you need.
Well, just a few minutes left in the program. Tony joins us from South Carolina. Tony, are you there?
Yes, I am. Good morning.
Good morning to you, Tony. We understand you have cancer, and we're so sorry to hear about that. But what did the doctor diagnose you with originally?
Well, I was part of urinating blood, and I went to my family doctor, and he referred me to a urologist in Aiken, South Carolina, and they done blood work, urine test, ultrasound my kidneys, and said I had kidney stones. Well, this went on about 6 weeks, and it kept getting worse and worse and worse, to the point I finally had to check myself to the hospital. Well, needless to say, by the time I got there, I was in stage 4 prostate bladder cancer, which they had to do surgery to remove my bladder and my prostate, and now I've had to take cancer treatments and stuff. And I can't understand why somebody's supposed to be a specialist kept telling me this. And he brought no other kind of tests, I'll
Yeah,
send it to
Tony.
another specialist.
Tony, let me try to answer your question real quick, okay? Tony, when you have something like this occur, you need to get to a trial lawyer who specializes in that type of litigation, medical malpractice. What has to be done is all your medical records have to be gathered, and then those records, including the scans and scopes and lab results, need to be sent off to another expert to determine if, under the circumstances, there was a breach of the standard of care. In other words, should that cancer have been disclosed earlier? And then you have the next question. If it should have been identified earlier and treated earlier, is the cancer the type that if they had treated it earlier, they could have avoided the consequence that you received? So a medical malpractice case is very difficult, but you're going to have to consult a medical malpractice lawyer and get a medical review of your records to determine if you have a claim.
And of course, he's just got a lot of bills in the interim.
That's right. It's tough on him.
Get it handled. Well, thanks so much for staying up and joining us. Next Sunday, the boys will be here to fight the insurance companies. Have a wonderful work week ahead.
Thank y'all for calling.